Well, let's go ahead and get started. It's 6 o'clock. I appreciate everyone coming out. I know it's a journey on a dark night. My name is Blake Bingham. I'm the Assistant State Engineer for the Division of Water Rights. This is the Mill Creek Subdivision public meeting for the general adjudication of water rights within that particular subdivision. I know there's probably a lot of questions as to what that really means and what the notice you received means and why you received a summons. Probably a lot of questions in your minds. So I want to make it very clear before we get started that you're not obligated to be here, although that summons may have given it the appearance that you were ordered to be here by the court. That's actually just a statutory requirement that we include that summons, so I apologize if that is a scary way to get your attention. But if at any time during this meeting you feel like this may not apply to you or you've satisfied your curiosity, feel free to stand up and find your way out and head on home. There's no need to keep you here if you don't need to be here, and it won't hurt my feelings. For the sake of time, I'll just introduce one other team member, Josh Zimmerman, back here in the corner. He's going to be the team leader who is responsible for this particular subdivision, so he's kind of my boots on the ground guy. We also have some other staff members that will be in and around after the meeting to help answer questions. So with that introduction, let's go ahead and get after it here. Let's go back here. So this is the agenda for the evening. I'm going to go over the overview of the general adjudication process, and then also talk about what a proposed determination is, or in legalese, it's the determination of all rights. So if you see that title at the top of that summons, that's really what we're talking about, is this general adjudication and that proposed determination. We'll talk about some of the significant issues in the anticipated timeline, and we'll answer questions. And really, if there are questions throughout the presentation that it may apply to the group as a whole, feel free to raise your hand and ask them. Even if you're unsure whether it does apply to them or not, feel free to ask. And if it's something that's more, applies to your situation specifically, I might ask you to hold off, and I'll stay after and answer any questions you have. For those who are viewing this live online, if you have any questions, that email address at the bottom of the screen, if you go ahead and fire off an email throughout the presentation, at the conclusion of the presentation, I'll review the emails and answer those questions so that the group can also benefit from those questions. If you happen to fire a question late in the process and it doesn't get read tonight, I'll still respond to you with my answer to whatever question you had in your email. So pause for a second for you to take that address down just in case you want to shoot an email. All right, long enough. So generally when we have these public meetings, there's a wide variety of interest and understanding of what a water right is or what the adjudication process entails. So I often like to start it off with just defining what a water right is. And really, a water right is the right to divert water from a natural source, such as a stream or a spring or a well, the groundwater, and beneficially use that water. The defining elements of a water right include the nature of beneficial use, so that's what the water right's being used for, whether it's for culinary purposes for your house or if it's used for irrigation. It might have a priority date, or it will have a priority date. That priority date suggests when that water right was first appropriated, and it kind of marks your place in line as water becomes less and less. If you have a more senior priority date, you get your water before people with a junior priority date get theirs. It has a defined quantity of water. We typically quantify that in cubic feet per second, which is we use a CFS as the acronym, or by a acre foot quantification, an annual acre foot. So if you can imagine an acre worth of property and water 1 foot deep, that's the volume of an acre foot would give you. It has a specified point of diversion. For groundwater rights, those are typically wells. It may also be on a stream. It would be the head gate. You would have a little point of diversion. You have a gate that you could open and close. And it has a specified place of beneficial use. That's just what it sounds like. It's where you use the water, whether it be your house or whether it be your irrigated yard or whether it be to water some stock animals up on the hillside. So we often get a lot of questions, and maybe some of you have called with questions. I don't know if I have a water right. And so I'd like to kind of give you may have a water right, or a water right is typically evidenced by some of these things. If you have a well on your property, there's probably a water right associated with it, or there should be. If there are irrigation ditches or head gates, that may be an indication that there's some type of water right. So generally, if you have a water right, you would know about it because you're either repairing the doggone well every other year, or you're maintaining the head gate or the ditch system. So for the most part, there are some instances when people don't realize they have a water right for some of these small wells in the Salt Lake Valley that flow freely. Some people just assume that's just part of their culinary system, but in some cases they find out that it is actually a well. What a water right is not, and there's often confusion between the concept of a water right and a water share. A water share is really a share of stock in an irrigation company or a water company. The water company itself owns the water rights, and then they sell shares of that water to shareholders. And so when we talk about water rights, we're specifically talking about the actual water rights and not necessarily shares. Now, does that mean that if you are a shareholder, you have no interest in this process? Not necessarily. You still want to, I know a lot of irrigation companies are kind of rent out of the glove box of a Chevy pickup truck. And you want to make sure that the board or the company itself is participating in this process. Otherwise, there's some severe consequences. So you should still probably be engaged in the process. Although when it comes to actually filing a claim, the company should be filing a claim on behalf of its shareholders. But we'll get into that a little bit later. A water right is not a connection to a public water supplier like Salt Lake City or South Salt Lake City. It's not the metered connection that you get from the city that you pay an annual or a monthly water bill against, all right? Now, there are water rights for that water, but Salt Lake City or whoever provides you that water are the owners of that water, and they are very engaged. Generally, public water suppliers, municipalities are very engaged in this process and will file claims, ahead of time. Whenever I do these meetings, there are a lot of questions, and really it's an attempt to understand why the heck are we doing this? Why are we getting this notice now? And so in order to really explain the process, I feel it's necessary to give a little bit of historical context so you can understand the value behind this process that would, result in you coming here tonight or taking up your precious time. And so bear with me for a few slides as I kind of break it down from Brigham Young on up to present day, just so you understand how this process evolved and why we are where we are today. So in 1847, we know the story that the Advanced Party of Mormon Pioneers entered the valley, and they started diverting the waters of City Creek to kind of soften up the ground so they could plant some late season potatoes, I believe is what they planted. They later built their mall on top of it. In 1848, Brigham Young kind of made this quasi, forgive the pun, prophetic statement that there shall be no private ownership of streams that come out of the canyons. These belong to the people, all the people. And that's still kind of the guiding principle in water rights to this day. The waters of the state of Utah are owned by the public. It's not owned by the state. The Division of Water Rights helps administer those rights and make sure there's an orderly distribution of those waters. But really, it's owned by all of us. It's a natural resource, and it continues to be owned by all of us together. Well, between 1847 and 1850, the pioneer, what we now know as Utah, really started out as part of Mexico and then went through this kind of quasi-ecclesiastical state of Deseret to the territory of Utah. So it went through this transition, but the pioneers continued to divert water. They were continuing to grow crops, irrigate those crops. And so really, the concept or the practice of irrigation and diverting water predated the state or the territory quite a ways. And so there was this kind of evolution of how are we going to regulate who gets what water. And so in the arid West, this is very important. Back east, where the pioneers were from, it just rained all the time, so they didn't really have to worry about diverting waters and irrigation. It just naturally, the precipitation was enough to satisfy the demand, or they had a different concept. Well, in the West, they decided that, there's a new, we live in a new environment. There has to be a new way to administer water and make sure people get their fair cut. And so diversions of water were generally based on how the community grew. And you can imagine Brigham Young sending out advance parties along the Wasatch Front in southern Utah, northern Utah, and Idaho, and developing communities. And so as those communities grew and developed, the water was kind of developed along with them. And it was essentially just enough to satisfy the immediate needs of those settlers. As a result of that, the doctrine of priority evolved with that concept. So the first settlers who got in there and started building the ditches, building the works, diverting, putting all the labor in, had the first priority or the senior priority on those rights. They got the primary rights. And then any follow-on settlers would come behind them. They would get secondary rights. And so those who had put in the most work had the best right, and those who come in later and benefited from the work of their predecessors got a secondary right. And this is actually a concept that really has its roots in Utah and actually then spread to other states. So the concept of primary and secondary rights was really almost established in Utah wholesale and then kind of exported as the pioneers went out west and as other people came west and tried to figure out the best way to administer water. And along the lines, the concept kind of evolved into the mining claim concept of first in time, first in right. And so you had this doctrine of the gold miners would come in and say, well, my claim is this date and your claim is this date, so I got mine first. And so this concept of primary and secondary rights along with these priority dates is kind of how we administer water rights to this day. Since there was no formal government, conflicts were settled through ecclesiastical channels. You had bishops' courts would kind of settle disputes among the ward members, the congregation members, and then if they didn't like what the bishop had to say, they'd take it to the stake high council. And the stake high council would say, "All right, bishop, you got this one wrong. This is really how it's gonna play out." And so the high council is kind of the appellate courts. But this is they had. They didn't have any formal government. They didn't have any courts. And so that's just kind of how they figured that they'd administer it. And this seemed to work for the most part, unless you're a non-member or minor or something like that. Maybe it wasn't as equitable, I suppose, but that's what they had. Well, as you go into the Territorial Era, the first Territorial Legislative Assembly passed an act that authorized the county courts to administer the waters, all right? And so this was an effort to kind of take the power away from what had been going on from the LDS Church and give it to the county courts. And it was a great concept. The challenge is that the people who were the bishops and the stake presidents were also the county judges, right? Because they were elected. And so you can kind of see it was a great effort, pretty much moot. And in the most part, it wasn't followed anywhere but besides Salt Lake County. Well, in 1877, in an effort to kind of incentivize homesteading of the West, the Desert Land Act was passed. And there are a couple consequences to this act. First, it severed title of the water from the land. So back east, if you lived adjacent to a river source, you had an automatic riparian right to use that water. Well, that doesn't work well in the arid West, where you need to divert water, convey it several miles, and then irrigate somewhere else. And so this kind of formalized that concept that you don't need to own the land to own the water. And it also delegated authority to the respective territories and states to develop their system of water rights. Now, that may sound something that's pretty common sense to us, but if you look at it through the context of history, where you had the government land office who provided patents, land patents, they're the federal agency responsible for providing land rights, you'd almost automatically expect, well, they're going to do the same thing for water rights. Well, this was pretty monumental in that it said, all right, states, you figure out how you're going to distribute and appropriate waters. And that's why throughout the West, we all have you go to Wyoming or you go to Colorado or Nevada, we all have our own flavor of how water rights are administered. But we have the Desert Land Act to thank for that. In 1880, the whole concept of giving the courts the authority, responsibility to administer water rights kind of didn't work, and so the territorial legislature just said, well, what we're going to do is we're going to appoint county selectmen, and they're going to kind of adjudicate rights, and they're going to hand out certificates of appropriation. It was deemed unconstitutional because you had kind of an appointed official, maybe from the executive branch, who was administering property rights, and that's kind of a no-no, right? So the property rights fall squarely, or the adjudication of property rights fall squarely under the court system. And so anyways, and again, it wasn't followed at all. So it was pretty much ineffective. As a result of this, confusion continued to exist over the distribution of waters in spite of the best efforts of the territorial legislature or the LDS Church. And the church continued to administer and decree water rights. A great example that I often cite is the 1879 High Council decision that administered or divided the waters of the Spanish Fork River, which is still followed to this day. There's been subsequent court decrees and other things, but that's how the waters were initially divided, and pretty much those same canal companies are the ones taking that water in that same quantity. So the church continued to kind of operate as the de facto settler of disputes. Well, in 1896, we know that Utah got its statehood, and there was a lot of concern from the different residents that that the state government was going to come in and confiscate everyone's water rights. They were going to say, "Oh, the water now belongs to us, and whatever you've been using, you don't have the right to do." And so there was a lot of worry about that. So rather than passing a comprehensive water law, figuring out how they're actually going to do anything, they just kind of punted, and they simply, wrote into the Constitution that all existing rights to the use of any of the waters in this state for any useful or beneficial purposes are hereby recognized and confirmed. So in essence, the Utah Constitution under Article 17 states that if you had been using water up to the point of statehood, you have a valid right. It's good to go. You don't need to worry about it. You kind of grandfathered in. And that's all they said. That's as much as they dared go. And so unfortunately, that left the whole concept of, well, how do you get rights now? How is this administered? It still kind of left it up in the air. Well, in 1897, the Office of the State Engineer was created, and that's what we now call the Division of Water Rights. It's kind of so my boss is the state engineer, and it's kind of a historic title that's been passed down from the original state engineer. But he's really just tasked with mapping out the state, determining where the rivers were, seeing what their flow rates were, seeing what the capacities they had. Appropriation, so if you wanted to get a water right, you still had to go hammer your claim in at the point of diversion, then go file a claim at the post office and the county recorder and the courthouse in order to secure that right. It was just pretty much all over the place. As you can imagine, there wasn't a whole lot of consolidated records or even people doing that. Well, in 1902, the United States Reclamation Service, what we now know as the Bureau of Reclamation, was established to reclaim the arid West, right? They wanted to promote people moving out and irrigating, and so they did this by building gigantic dams and compounding lots of water. But they went to the states and they said, hey, states, the problem is, we're not going to build anything in your state unless you figure out who owns what water rights first. And the states are like, well, Utah in particular was like, well, we don't really have a system for doing that. We've just kind of been getting along as best we can and letting the courts decide it whenever it comes into controversy. Well, the Reclamation Service said, well, figure it out. You're not going to get a project until you adopt some type of statute. So it's no coincidence that 1 year later, the state legislature enacted its first comprehensive water law, which provided for appropriating new rights, but also recording of all existing rights. Remember all those diversions that have been going since the pioneers first arrived in the valley. And also for adjudicating those rights. So in essence, the courts were responsible saying, well, he claims this right, he claims he's been using it since 1848, and this guy claims a right, and they're going to fight it out. And so the court's responsible for adjudicating it. Unfortunately, the legislature just said, all right, court, that's your job, figure it out. And they didn't really provide any funding. They didn't provide any mechanism. And those of you familiar with legal proceedings, it's kind of a oppositional proceeding. You need someone saying, I want this, and someone saying, no, you can't have that. And they fight, and the judge decides. Well, it's really hard to do that if you just have a bunch of water rights. You're not going to see a judge go out there and trying to figure out who's owning what water rights. It needs to have a court case come before him. And so really, the concept or the concept of figuring out these existing rights just kind of fell on its face because the court just didn't do anything with it because there's never any court cases brought before it. Well, in 1919, the legislature finally figured out the trick, and that's he gave the state engineer the responsibility for creating a proposed determination and then submitting that to the court. So in essence, what happens is the state engineer was responsible for going out, observing the water rights, making his recommendation as how he thinks it should work out based on his expertise, and then taking to the court and saying, all right, court, here's the case, here's our recommendation, and then parties who don't like it can come in and oppose it. And so that's largely the same process that we use to this day when we talk about general adjudications or water right adjudications or proposed determinations. It pretty much falls under the same process with some minor tweaks over the years. And then, so you recall, 1903 was the first law that was passed that dictated how to appropriate water rights. Well, that was only for surface water. You didn't. Back in those days, you didn't need a water right to drill a well because they kind of looked at surface water and groundwater as completely separate. Well, we know better than that, and they probably actually knew better than that back then as well, but they just decided not to deal with it. Well, in 1935, they finally decided, well, since these are all interconnected, and if you drill a big well, it could impact a surface right somewhere else, and vice versa. What we're going to require is if you have a well, or if you want to drill a well after 1935, you need to appropriate that. So prior to 1935, you didn't need a water right to have a well. And so if you had a well prior to 1935, you're kind of grandfathered in. Well, as you can imagine, prior to 1903, prior to 1935, there was people using water, but no one knew about it. And so that's in essence part of what we do, and we'll kind of get to that here in a second. So prior to that enactment of that comprehensive water law in 1903, water rights kind of fell into one of 5 different categories. You had those that were decreed by ecclesiastical leaders. You remember the Spanish Fork River, that's how they're going to split that out, or the two different parish members of the congregation got in a fight. They say, you have this right and you don't. You had those claims that were filed for record at the county. So remember the old system of staking your claim and then going filing it at the county. You had those that were decreed by court, and those were generally when people disagreed and went to the court and the court made a decree. But the problem is those were only limited parties. So if you had, 2 people fighting over water, that's great. The court could decide between those 2 people, but what about the 3rd, 4th, and 5th, and 6th people on the river? They never really determined whether either of those people have a right compared to those other people. So that was kind of the limitation of the court decree. You had contracts or agreements among limited parties. We have some of those in the Salt Lake Valley, especially between Salt Lake City and different irrigation companies who filed exchange agreements. And then you have those claims that were never manifested on any record. These are the people that continue to use water, whether it be prior to 1903, the surface water, or prior to 1935, the groundwater. These are people who just continued to use it, and they had every right to. But we just didn't know that they existed, right? Because they never came into controversy. So as a result, as a consequence of not having that definitive water law, there's a number of issues. First, there was typically no public record. And because there was no public record, over-appropriations of the streams and the groundwater was common. And because it was over-appropriated, there was a lot of controversy amongst different water users. And they tried to get settled by either court decree or ecclesiastical decree. Well, so the state engineer every 2 years is required to file a report. So in one of his first reports, the state engineer said, the definition of existing rights appears to be, I have to read it down here, of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record. So the theory was, what we're going to do is we're going to find out all these existing rights before we start appropriating new rights. It was a great theory, it just never worked out. It's because the demand to appropriate new rights was just too great. And so they said, we'll get to adjudicating rights later, we'll figure that out, but let's just go ahead and start appropriating rights. And so that's where we are today. We have this system of appropriation, and we're also doing adjudication, trying to find out all these old existing rights. So what is a general stream adjudication or a water rights adjudication or a general adjudication? It's an action in state district court for the Utah Lake Jordan River. That's that purple blob you see there on the screen. The center. So that's that whole, when we talk about the general adjudication, we're talking about that whole landmass that covers Salt Lake Valley, Utah Valley, and up into Heber. So in essence, the Provo, Spanish Fork, all these tributaries to Utah Lake and the Jordan River. So this is an action in state district court. The Utah Lake Jordan River adjudication is actually started in 1936. Salt Lake City, there was a huge drought. Salt Lake City didn't like the fact that people were throwing pumps in the Jordan River and pumping it out, so Salt Lake City decided to sue like 2,000 people. And the court said, yeah, you can't really do that. We need to do it as a general adjudication because there's other things to contemplate. So they took it to the Third District Court, and that's where we are today. The general adjudication binds water users and the state engineer, so it gets all people within the subdivision and binds them. It's completely inclusive, right? It doesn't leave anyone out. That's the title of code it's governed by, Title 73, Chapter 4. And the first general stream adjudications took place in the 20s. You'll recall a few slides back that 1919 is when the legislature first give the state engineer the authority to create a proposed determination. So the state engineer kind of started doing that. The Depression helped out a little bit because there was a lot of free labor. And so the CCC was used to kind of take care of the Weber River. We actually have adjudicated the Weber River. Hold on one second, I'll finish my thought. And the Sevier River. So the Weber and Sevier are completed. Virgin River got completed, then they reopened it in the 80s. Yes, sir. Can you define adjudication? So can I define adjudication? Yeah, well, as the name implies, it's really an action in court, a court action, right? So the judge at some point is going to adjudicate these water rights and determine what ones are valid and what ones are not valid. The state engineer's part in that is he offers the proposed determination, compiles the proposed determination as kind of his official recommendation to the court. And the court says, well, is there anyone doesn't really like this, and waits for him, and if no one says, all right, hominis dominus, decreed, right, adjudicated. Anyway, so as you can see, throughout the state of Utah, we have a general adjudication that covers pretty much every inch of Utah to determine these rights. Most of them are not completed. There's been a lot of emphasis in trying to finish up the Utah Lake Jordan River adjudication, but you can see the size of it, right? It's pretty big. I mean, it looks pretty small in this graphic, but it's huge. A lot of people live here, and so what we do is we carve it up into divisions and subdivisions. And so this is the Mill Creek Subdivision of the Utah Lake Jordan River General Adjudication. So when you see the subdivision term, it's not the traditional neighborhood subdivision. It's just a geographic boundary of the Utah Lake Jordan River General Adjudication. So why do we conduct general adjudications? I kind of talked some of this already, but we want to bring all claims on the permanent record. You remember this guy who's kind of using water, not ever bothered to file a claim? Well, the general adjudication forces him to file a claim, or tells people, file your claim, otherwise this is your chance, and if you don't, you won't have any kind of grandfathered rights. So when we talk about diligence claims, that's kind of the term that was given to surface rights that predate 1903. And when you talk about underground water claims, those are the same thing, but just for underground water, subsurface water like wells prior to 1935. So we call those altogether pre-statutory, meaning they are rights used before the statute applied to them. We also have this concept of Federal Reserve water rights, and I don't want to get too far in the weeds in this, but it's pretty significant. In the state of Utah, we have a lot of federal land, so this is kind of a big issue. So on the Fort Belknap Indian Reservation, there was a tribe of Indians who wanted to appropriate water on the Milk River. However, all the settlers around the Indian Reservation had already diverted the water and said, well, you can't, and Montana's the guy that's going to decide whether you get water or not. And Montana said, sorry, this water has been fully appropriated. Well, the tribe wasn't too pleased about that, so they sued, and went all the way up to the Supreme Court. The Supreme Court said, by virtue of the fact that Congress had reserved that reservation, there was an implied water right that went along with that went to sustain the lifestyle that Congress intended for the Native American tribe. And that was an agrarian lifestyle, right? And so they said, well, there's an implied water right that's equal in priority to the date of the reservation. So they they pulled out the trump card, and that's their trump card. They got the Federal Reserve water right. It predates all the settlers. And so that doctrine, called the Winters Doctrine, has been subsequently applied to other types of federal reservations. So national parks, national monuments, Forest Service, not just Indian reservations, but we have our fair share of Indian reservations in Utah, but we also have a lot of Forest Service land, and we have a lot of national parks. These all come with these Federal Reserve water rights. And the thing about the federal government is you can't sue them unless they let you sue them, right? They got federal sovereign immunity. So you have to get their permission to actually sue them. Well, and so you can contemplate that the precarious position that places water users if they're living in some of these areas adjacent to these reservations, that they don't know what the federal government's water right is. They know maybe what the priority date is, but they don't know how much that water is for until the federal government come forward and said, this is what it is. And the court said, yep, that's what it is. Well, Senator McCarran was a senator from Nevada, and he saw that, hey, this is a real stumbling block for Western states to have this shadow of federal government with their gigantic unquantified water rights just kind of looming over the heads of these water users. And so he passed a bill in Congress in 1952 that said, it's the McCarran Amendment, and in essence, it waived federal sovereign immunity with respect to general water rights adjudications. So what that did is it said, all right, federal government, you no longer have federal sovereign immunity when it comes to these proceedings. The state can sue you in these, but only in a general adjudication. It can't be onesie twosies. And not only that, we're going to force you to do it in state district court. So, it's kind of a great deal. I don't know of any other type of act that does this where you can take the federal government to court and you can do it in state district court. And so that was an effort to force the federal government to come forward and quantify those water rights. So the general adjudication is kind of that Damocles sword hanging over the federal government's head saying, come forward and tell us what your claim is, and then we'll figure out whether we like it or not, and then we'll go to court over it. Otherwise, they would just continue to be obscure and undetermined. All right. Another reason why we do general adjudications, we want to prevent a multiplicity of suits. We don't like a lot of people suing other people. That's no-brainer. Kind of maybe the more controversial aspect, and I heard someone say, whenever we have these types of meetings, it probably means the government's going to take something away from you. And I'm afraid bullet number 3 is probably where we're going with that direction. So throughout the western United States, we know that water is a resource that's limited in nature, right? And so all of the western states that I'm familiar with have this concept of use it or lose it. So if you don't use your water right, it needs to go back to the public so it can be used somewhere else. And really what this was intended to do was to incentivize people to actually use their water and to use it beneficially, but also to prevent monopolies from accumulating water rights and then holding the public hostage. And so, it's controversial because people say, well, I have this well and I've had it forever and I haven't used it for so long. How can you take that water right away? Well, if you look at it in the big scheme of things, that water is being used somewhere down the hydrologic system, right? Someone downstream is using that water. And so is it fair for you or someone to suddenly, after 50 years of not using the water, to start using it again when someone's whole communities or farmers have built their lifestyle around the use of that water? And so that's really why the founding fathers wrote that into the water line, and you'll find that in pretty much every western state that has this concept of prior appropriation doctrine. So in Utah, the rule is if you don't use your water right for 7 years, it's subject to forfeiture or abandonment, okay? And this is usually the time I get a bunch of questions, so you guys are kind of a shy crowd, but usually after one person asks a question, the floodgates open. But feel free to ask questions. So that's the concept. Yes, sir.
So what constitutes use?
Well, pretty much a lot of things, you know. We don't like to, so I guess if you're using it for something, you know, you can't waste water. I wouldn't say turning on your hose and running it down the curb and gutter constitutes use, but turning on a hose and putting it on your yard would probably constitute irrigation, right? And so it's pretty broad, and from our perspective, we want you guys to use your water. So when we come out to observe these claims, and we'll get to that in a little bit, we do everything we can to kind of give the benefit of the doubt to the water users, because we want to encourage people to use the water. Any water rights that are forfeited don't go into some magical pot that someone gets to buy or sell or we get proceeds from. They just get pulled from the stack, and the next person in line, next man up, right, gets the water. So we really want to encourage people to use that water. And when we come out to look at these water rights, and again, we'll get to that in a little bit, my recommendation is don't, put it to use while we're there. Put it to use. Figure out how to get it working before we get there, because we're not really interested in kind of becoming Sherlock Holmes and figuring out whether you truly have been using this water in the last 7 years. You know, if we show up and you're using your water right, good to go. No need to really look further. So, all right, here we go. Yes, ma'am.
Well, if I understand right, we're not talking about the water that we're watering our lawns with, because that's municipal water, but we're talking, how are you going to, is this water metered?
So a couple questions there. She said, first I wanted to clarify that this isn't the water that is coming from the municipality, which is correct. The municipality, it is, but you don't need to worry about the municipalities taking care of that. Is this water metered? Generally, water rights that are diverted by private owners are not metered, unless it's part of the requirement that the state engineer says, hey, you need to meter that, and that's generally not the case.
How do they measure it?
So the question is, how do you measure it? Well, there's certain ways you can measure it. Kind of really quick 101 on how appropriations go. When you file a water right, you're required to file proof on it once you've put it to beneficial use, right? So you got to prove that you're using it, and when you do that, generally an engineer will come out and measure what the flow rate of the well is, or measure to make sure that you're within your prescribed appropriation limits. Yes, sir.
We've got a certificated water right. The point of diversion is at the top of Mill Creek Canyon. And it provides water for about 2 dozen cabins. In order to submit our claim, do we have to provide declarations or affidavits of use by all of these cabin owners for 7 prior years? What do we have to do, or what will be anticipated?
That's a good question.
So that we can get going now.
Okay, let me just repeat it for the sake of the rest of the audience here. So this gentleman, they has a certificated rights. Then what that means is that's a right that's been appropriated. They filed proof, and the state engineer said, yep, here's your certificate. You're good to go. He has these good water rights at the top of Mill Creek. They supply water to a subdivision. When they file their claims, what are they required to file? Are they required to file affidavits saying that, no, we've been using it for the last 7 years? No, really all you need to do is file a claim, and then we'll come out and we'll just look at it. And we'll get to what that looks like and how that's going to roll. But just file your claim, and then we'll come out and investigate the claim. It's pretty straightforward. We try not to make it as too hard. How are the claims submitted? We are going to get to that in just in a couple slides. So you beat me to the punch. Let's go here. Yes, sir.
I'm paying about, I think, $70 or something per year for the water membership fee. You still have to claim.
So he says, I pay a fee for water. Do I still need to file a claim? My guess is you're probably paying either an assessment fee or you're paying a utility bill based.
I got a share.
It's a share. Okay, so you're paying an assessment to a share as part of your share, right? Typically, the irrigation company or the company to whom you pay should file the claim on the behalf of the company itself. But that, like I said before, follow up with your shareholders or your board to make sure that they do this, that they participate in this process. Let's go over here, and then we'll go over here. Yes, sir.
If your water has been approved by a state engineer, are you good to go, or does that still need to be?
So that's a great question. If you filed proof on your water and you have a certificate, Is that enough, or do you still need to participate in this process? You still need to participate in this process. You still need to file a claim. Yes, ma'am.
I inherited this property, and McHugh always told me that it came with a right or a share. I don't know what it is. How do I find out what it is I have?
So her question is, she inherited this property. She was told that she either had a water right or a share that were associated with it. How do I know what I have? We can certainly take a look at our database and see if there's something that would indicate a water right. Otherwise, if your neighbors, usually if it's a share, your neighbors probably have shares and they might know, so I'd ask your neighbors. But to answer your question, how do you manifest that? Do you use water other than turning on the tap in your bathroom?
No.
Yeah.
Go on and
And so if you do, so what I'm saying is, do you have a well? Do you have a ditch that you go and get the head gate open and turn heads? So yeah, or you block something off.
Water my garden.
Yeah, and so there's some so to answer your question, I don't know what water right or share you have. How you find out, we can certainly try to help you if you want to come in and we can look at it and see what evidence on our records may indicate the existence of a water right. So his question, I've got to come in here and go to a clerk. No, you don't have to do anything. It's whatever you want to do to, they say, like, no gun to your head. We're happy to help you, but yeah, so if you want to know, we will offer our assistance to the best of our ability to help you determine whether you own a water right or a share or nothing.
Are you located here?
Yeah, so the question, are we located here? Yeah, we're actually just right upstairs on the second floor in the old building right here.
And I just go up there and ask them.
Yeah, if you walk in, that's what we do. Or you can call ahead, make an appointment, however you'd like to roll. Let's go over this. Yes, ma'am.
You spoke of the law in 1903 and 1919, and I received yesterday a 12-page copy of a court hearing on Judge Morse.
Mm-hmm.
And it's called the decree, the Morse decree in Mill Creek. You have to mention that, and it is dated 1913.
Sure. So you recall, so her question is, I've mentioned this law in 1903 and then this law in 1919. It kind of governs how we adjudicate. She's got her hands on a decree from Judge Morse, who is pretty active in this realm, from 1913, right? It's the Mill Creek decree by Judge Morse. How does that work into this? Well, so what Judge Morse did is there were a limited number of parties along Mill Creek that didn't like each other or were fighting over water. They took it to court, and Judge Morse issued a decree. So he settled the water rights with respect to those limited parties. It did not include everyone else in the valley who might be tributary to Mill Creek's obviously tributary to Jordan River and so on and so forth. And so we look at the Morse decree and we honor it because it's a decree and those are decreed rights, but they are still subject to the general adjudication because it was a limited adjudication. But it's still important, and there's still valid rights. Okay, I'm going to take 2 more questions. I'm going to drive on the next slide, and because we got to get past through this. All right. All right. You haven't had a chance yet.
Yeah, I belong to an HOA. I've got a kind of a high water table, and a lot of the units have got sump pumps that when the water table rises, they pump it out, pulls out onto the common area to use for irrigation, like that.
So his question, so he belongs to an HOA. In this area, they have a shallow water table. They use sump pumps to dewater their foundations or their basements, whatever, what have you. I presume that's what you're referring to. And they pump this water, and it discharges onto the land, onto the grass, and happens to probably incidentally irrigate that grass. Does that constitute a water right? Doesn't constitute a water right. We're kind of bordering on the line of illegal water right, maybe, but no, that's just dewatering, and I don't think we're really in the business to crack down on that. But if you're asking, well, does that constitute a reason to file a claim? We'd probably say no, probably not. Okay, one more. Yes, ma'am.
Is there a dollar amount applied to a water right?
Is there a dollar amount applied to a water right? That is a great question. It's kind of like asking how many pancakes does it take to shingle a doghouse, right? It's just like, yeah, there probably is. I mean, would you buy a water right? If you wouldn't, then probably $0 associated with that water right. There might be more. So typically, though, I'm being a little facetious. In the Salt Lake Valley, water rights are valuable, and that's why we get a lot of bogus claims that we're required to go and investigate. But certainly, like I said, it's a resource because in Salt Lake Valley, most of Utah actually, it's closed to new appropriations, meaning you can't go and appropriate a new water right. You either have to acquire it, you just have to acquire one from someone else. You have to buy one. So obviously, law of supply and demand, if the supply is low and the demand is high, price goes up, right? And so the Salt Lake Valley falls under that. I'm going to go through the next slide and then I'll do another round of questions. How about that? Just so that we can be fair to everyone. All right. At the conclusion of this process, we want to obtain a final inclusive comprehensive decree. So it'll be inclusive of Judge Morse's decree and all these other water rights, and we'll get one big decree. We'll get one for the subdivision, and then once we get all the subdivisions done, then we'll get one for the entire Utah Lake Jordan River that will incorporate these, what we call interlocutory decrees or separate small decrees. All right, the adjudication process is kind of a three-phase process. Phase one, we're pretty much at the last tail end of it, okay? And I'm going to go into phase three and two and three in more depth. And this slide deck will be online, and as well as this presentation. So if you want to take a picture of this, great. If you want to look at it later, it'll be online, available for download. So we kind of separate it into the initial notice part. This is kind of the culmination in this notice part. And then we kind of go into the claim filing portion, and then the claim investigating portion, and recommendation to the court. And so step 5 through 9 is kind of when we file claims and we have another public meeting and we talk about, so I'll just touch on this. You'll have another notice here in the next couple of weeks that will say, all right, it's time to file a claim. You will have 90 days to file a water user's claim for water rights on our record. So in our division, we have a big area upstairs just full of files, right? And those are water rights that we know about. And so we call those water rights of record. Now, there are a lot of water rights that are not of record. You remember the guys diverting water, the Dos Equis guy? He's the one that's irrigating water without a right. So when we talk about water rights of record, I'm referring to the ones that we know about. Well, if people fail to file a claim on those water rights of record, such as the certificated claim up in Mill Creek or a claim that a right that's been proved to otherwise, those rights will go on what's called a list of unclaimed rights, meaning you failed to file a claim within 90 days. It's going to go on this list, meaning it hasn't been claimed. And then what happens is if that list then goes before a court and the court orders that those rights are deemed abandoned because people failed to participate in this process. So that's why it's important to participate in this process to avoid that cutoff, okay? So once we get claims, and again, I'll go into this more detail here in the next, just to kind of wrap up this slide. We get the claims, we'll go out and we'll investigate the claims. So if you file a claim with us, one of my team members will probably contact you, come knock on your door, try to look for your well, see what use you have at the time. And then we will determine, is this a valid claim? What's the extent of the claim? And we'll make a recommendation in the form of a proposed determination. So that's, again, the state engineer's official recommendation. It's called the proposed determination. We publish that. We give people 90 days notice saying, hey, if you don't like this proposed determination, you can file an objection, meaning you go to the court and you actually say, court, I object to this proposed determination by the state engineer. My water right really should look like this. So you have 90 days to do that. We hold a public meeting, and then we have to resolve those objections. And hopefully, by the end of the day, we resolve the objections. We petition the court to decree those rights in that proposed determination. So for this subdivision, we will have one list of unclaimed rights and one proposed determination. Kind of similar type processes, but different end results. The list of unclaimed rights that are listed in there, they go away. They get deemed abandoned by the judge. in the proposed determination, that's where we define the rights. We say, oh, this is how many acres of irrigation this person has, this is where their point of diversion is. And it'll also list the rights that for claims that were filed that are bogus, right? And then we recommend those be disallowed. So if someone files a claim saying, yeah, I have a 1805 water right out of Mill Creek, it's pretty awesome, we're going to come out as like, well, there's just no way you can have an 1805 water right, so it's obviously a bogus claim. Or if there's some other evidence, we'll recommend that right to be disallowed by the judge. And ultimately, it's the judge who makes the final determination and issues a decree. So let's kind of talk about filing your water user's claim. Josh, are you still in here or do you step out? You stepped out. So I think around mid-December is when we are going to send out the notice to submit claims. All right, it'll go to the same group of people who received the initial summons. So that's something like 9,547 people or entities that we sent that initial notice to. And the reason we did that is we don't know who has water rights. Remember, you got people who may have rights that have never come forward. So we just send it to all property owners within that geographic boundary, and that's why you receive this notice. Simply receiving the notice doesn't mean you have a water right. We just want to make sure that we have sufficient due process. So we will mail these notices to submit claims to all the property owners and water right owners of record. And we'll also publish the notice in the Deseret News and Salt Lake Tribune. In that notice, you'll have just a form that says this is your notice to file a claim, and then it'll give you a blank water user's claim, or actually the form to fill out if you want to file a claim. If you're a water right owner of record, such as the gentleman with Mill Creek or this other gentleman who had a certificated right, the claim will already be filled out with what is on our records. So in essence, it's already populated with the water right of record information. All you need to do is review, and if you feel like making edits, go for it and sign, and you can either, I'm kind of getting ahead of myself. So you'll either get a blank claim if you're a property owner or we just don't have record of any water rights, or you'll get one already populated if you're an owner of record. You'll have then 90 days to file a water user's claim. You can either file those claims here at the Division of Water Rights upstairs, or you can file them at the county, or excuse me, at the district court, Third District Court. If you come here, or you can come here and we'll help you fill out your claim. If you're just not sure what you have, but you want to file a claim, come talk to us, schedule an appointment, or call us. We'll try to help you over the phone. Sometimes that's a little bit challenging to kind of articulate how to fill this thing up through the phone lines, but we'll do our best. Within that 90-day time frame, so you'll get the notice and you have 90 days to file a claim. You can request an extension, a 30-day extension, and it's automatically granted, but you have to do that request within the 90-day time frame. And you could do that by emailing me or emailing that address that was at the beginning of the presentation or emailing the team leader. Just get a written request into us, or there's a form online that you can fill out and bring in as well. And then that's automatically granted. You don't have to explain anything. You just say, I just want a 30-day extension. So that will give you 90 days plus another 30 days, give you 120 days in total. Once we receive those claims, we go ahead and investigate them. So it's our obligation to go out and evaluate these claims, make sure that the point of diversion is where it says it is, make sure that the beneficial use claimed is really what is there. And then these claims, once we evaluate them, we formulate the state engineer's recommendation that becomes the proposed determination. Remember, the proposed determination is the official recommendation of the state engineer. So we look at these claims, we come up with our own assessment of them, and then we create the proposed determination. Now you remember the list of unclaimed rights. So for water right owners of record, or water rights of record, those are rights that we have on our records, and if someone fails to file a claim for those rights, they get listed in this book, okay? You'll receive that notice. You'll receive notice of this book, the list of unclaimed rights, that it's been published with a web link where you can access the PDF version of it. And then we'll hold another public meeting like this where we'll explain it. Usually that's pretty sparsely attended, but we were obligated to by statute to do that, and we're happy to. following the publication of the list of unclaimed rights, you can file an objection if you do so. So if you see a water right that you believe you're an owner of, and it's on that list of unclaimed rights, you should file an objection. You need to file it with the court. We would really appreciate a courtesy copy, but we'll get it from the court one way or another if you file it there. You can file the objection and say, hey, I didn't intend for my water right to end up on this list. Here's the reason why I failed to file a claim on time. When you do that, you're also required to file a claim with that objection. So at that time, you need to file the water user's claim with your objection. Again, if you're confused, which you probably will be once you get to this point, come in. We'll kind of talk you through it. I know this is a lot of information, and it's not super intuitive. So objections to the list of unclaimed rights are pretty straightforward. Unless it's just a blatant disregard for participating in the process, we're probably just going to say that's fine. Let them file a claim because we'll have an opportunity to review it later. But we have to resolve the objection before the court issues the decree on the list of unclaimed rights, adjudging all of those lists of unclaimed rights, all the rights on that list, as being abandoned. Okay, so it's the judge that does this. People who don't want their right to be abandoned need to file an objection. Again, you'll get notice of all of this. At that decree, what that also does is it cuts off anyone from filing a claim in this area henceforth. Okay, meaning the Dos Equis guy can't file a claim, right? The people that had these rights, these grandfather rights, these diligence claims or underground water claims, they're donezo. They failed to file a claim. This cuts them off. All right, so that's why it's important to file a claim. If you're in doubt, file a claim or bring it in. Come in, talk to us, and we'll let you know if you really need to file a claim, or at least we'll help explain it. Yes, sir.
I'm assuming that if we've got a water share from a company and not a right, then our responsibility is to talk to the company that's running that, and they'll file a claim, not us.
Yes, that's a great question. So for those individuals who have shares in an irrigation company or a water company, it's really the responsibility of the water company to file a claim. But again, it's probably beneficial as a shareholder to ensure that your water company actually files a claim to prevent their right from being considered abandoned, right? And so you want to make sure that you're telling them, if you happen to file a claim on your share, we'll count it. We'll just say, good to go. We won't put it on the list just because we don't want to. Oh.
So continuing on with this, if you own shares in the company, how do you determine whether the company is using it? Do you need to go out and make sure I'm using my water like throughout the company?
So his question is, if the company files a claim, how are you to make sure that the company is using it all? Well, you don't have to. Pretty much I'd encourage people to just file the claim for whatever the right is. And if the company's not using all of it, we'll come in and we'll evaluate it and we'll determine the extent of the beneficial use.
Or so independent of the company. So I belong to East Mill Creek Water Company, and so we get shares down our ditch, and I'm wondering if you need to come out and verify.
Yeah, so we will come out and verify where those shares are flowing, where that water is being used. Yes, sir.
Is a warranty deed that includes so and so many hours so is that a claim or no?
So his question is a warranty deed that specifies so many hours of a turn on a ditch or something like that, does that constitute a claim? No, a claim is the form that we will send you. It's a very specific form that articulates, or rather delineates, where the point of diversion is, how much, what it's being used for. So there's a lot of different things that are to be required to fill out. Now that warranty deed's useful to keep around, obviously, especially if it's a water right that has someone else's name on it and you need to update title to show that, hey, you are the actual owner of that water right. Okay. Yes, sir.
So once this adjudication process is finished, then all these decrees, like the Lawrence decree, will be negated.
So his question statement was, once we get all of these interlocutory decrees and ultimately a decree that these limited decrees like the Morse decree and whatever other decrees will be negated. Yeah, in essence it will be, but typically those decrees shape how the final decree looks, right? So we give a great deal of deference to a decreed right in that sense and say it's a decreed right. The court has created a property right. This is the property right. This is how the right should look. And usually that's the basis for the right. Unless they're not using all of it, then it might get trimmed. But in essence, all of those limited decrees get subsumed into the comprehensive decree. Yes. Yes, ma'am.
Well, a couple things. Can you just kind of help me understand what's driving this? I mean, it's been going on for over 100 years. People are using the water, they're gardening, it's working for them. And then as a second kind of follow-up to that, can you either validate or dispute? I've heard rumors that Salt Lake County's wanting to buy water rights or acquire them for development purposes. So if we aren't using it, then is that of a value from a development standpoint for Salt Lake County?
So 2 questions. First one is, can I shed some light on what's prompting this? You know, it's been going on for so long. People haven't had any issues. Why now? The answer is it's just because it's your turn, right? We've worked our way around the valley, and we're finally at Mill Creek, and we're kind of working our way south. We've done City Creek and all these other areas, and it's just, we're just trying to, so there's been some emphasis on adjudicating the Salt Lake Valley for the last 5 years, just because that's where the greatest development has happened. So all these big 10-acre lots are now subdivisions or Walmarts or whatever, and so there's a need to know what the paper water is and how it matches up with the wet water, is how I would like to say. So there's nothing particular about why this is happening in your area now. There's nothing driving that other than we're in the we're in Utah County as well, but yeah, there has been a little bit more emphasis to get through Salt Lake Valley and just get it done, you know, because the divisions kind of put it off because it's hard. There are a lot of people, a lot of complicated water rights, and so there's been lower hanging fruit elsewhere in the state that these efforts have been focused in on to some degree. So I was going to get at, so is it a leverage thing? No, you know, to answer your second question, is there some value to the county? Can I confirm or deny or speculate with respect to the county's interest in acquiring water rights? I don't want to speak for the county. I'm not their representative. We don't really communicate that much. They participate in this process like every other person, and you know, they file claims. Now, whether they have interest in acquiring water rights, most municipalities have an interest in acquiring water rights because they are, you know, they have the burden of providing enough water for the future anticipated growth. And so generally that drives their need to acquire those waters. But this has nothing, this general adjudication has zero to do with that process. Although that's an often it's a misconception. Back in the back, yes ma'am. Yes, you in the white coat, you got it.
So what happened, you've got this box of water right claims that you have somewhere, and you'll add more, people will make more. But are those listed by name or by property?
So you may need to clarify your question.
So is it a lot that has the right, or is it the owner of the lot that has the right?
Okay. Her question is with respect to how the water right is owned. You know, does it have to stay with the lot or does it stay with the owner? So it's a good question because it's kind of tricky in some sense in that in Utah, water rights are generally pertinent to the ground upon which they're used. And so when you buy a house and the deed conveying that property to you is silent with respect to water rights, it's assumed that the water rights, if there were any, transferred with the property. Unless in the deed it explicitly withholds those water rights. And then those water rights are assumed to have stayed with the owner. That makes sense? Now we have our records that say who we think the owner is, but the true ownership records are at the county recorder. You know, they're the owner of record, they're the record of record, or whatever you want to say, for property rights. So, yes, sir.
I have a particular question. My grandfather came across the plains with pioneers, and Brigham Young granted him a land grant from Highland Drive to 6th East and from 33rd to almost 5200 South, with all water rights. I had a share of Mill Creek Water, I had a couple of shares of Big Cottonwood Lower Canal Water, and I had 7 springs.
So this sounds like a little bit of a specific question that's tailored specifically to your situation. So let's hold off on that, and then well, you can ask me later, and I'm happy to dive into Brigham Young's issuance of property rights. And
Water company just ceases to exist.
sorry, what was the last part?
What happens when a water company just ceases to exist? The Mill Creek water that I had a share of it, and it just died.
So the kind of through all the details, the actual question is, what happens to the water rights associated with a company when the company just goes away? All right. So we're kind of like veering into property law. So really, if a company disbands in Utah, an organization disbands, there's this unwinding of assets that's supposed to happen, right? And I'm not going to get into that because I'm not a lawyer, but you can certainly talk to one.
I asked the state one time about my springs, and I said the springs were granted to my family, and when they were granted to me, they also granted.
So let's move on. It sounds like we have a specific situation. I'm happy to really am, but in deference to people's time. But yes, ma'am, did you have a question? And then I'll get to you, sir. Go ahead, ma'am.
Okay, I've owned a house in Mill Creek for 30 years. Nothing's ever come out like this in 30 years. Suddenly Mill Creek has become a city, and now we're receiving this kind of paperwork, and this is going to happen. Is there a connection?
So her question was pretty much the same question. Is there a connection between development and this process? There's a tenuous connection in that there's a lot of paper water. So the Salt Lake Valley is over appropriated by double, right? So we got twice as much paper water as we do wet water. And as you can imagine, as the place is urbanized, big irrigation fields have now become parking lots. And so there's a need to determine, hey, what is really being used out there so you can get a handle on that. But so this process is kind of generally associated with the urbanization, but not driven by it. It's not driven by any particular municipality or any type of development, anything like that. It's just, hey, we live in an area that is growing insane right now. We need to get a handle on what water rights are out there, what are still being used in order to plan, be good stewards for our future generations. So there's no direct connection. Yes, sir.
We have rights of record that have passed through inheritance as part of the general estate along with the land. But they're probably still in my grandfather's name. Is this application or making a claim the appropriate place to get the names changed to the living owners now, or is that a separate process?
So if I understand, you own some land, you have some water rights of records, and you're talking about the water rights themselves or the property?
No, the property's already in, the title of the property's already changed.
Okay, so you're talking about the water rights. Yes.
It's going to be in my grandfather's name.
Great question. So, his grandfather had this land, had the water rights. He conveyed the land. The water rights went with it, but on our records, it's probably still in your grandfather's name. Is this a good opportunity to clear that up? And I'd say, yes, we encourage you to, but don't let it prevent you from filing a claim. If you file a claim, we'll just say you're a claimant, and we'll still recognize and still evaluate it. But there's a process called a report of conveyance. It's a separate process in which you can update title on our website. You might ask, well, what does updating title with an estate engineer do for me? What that does for you is if you have a well that needs to be renovated, you need to be the owner of record before we'll allow you to renovate that well. Or if you want to file a change, sell it and file a change, there's going to be a couple things, no one's going to buy it from you if you're not shown on our records as the owner of record, because that's kind of a risk. So I would encourage people, as part of this process to update title, and we can kind of show you how to do that. That's not really our lane, but we can certainly, I'm going to hold off on questions. I'm almost done with this presentation, and those who want to leave can leave, and then we can talk over and we can answer questions all night long. So once the list of unclaimed rights has been decreed, we take all those claims that we've observed, that we've evaluated, and we put in the proposed determination. In essence, it says what the water rights should look like. Once and we map those, we do what's called a hydrographic survey map that shows where the irrigation's occurring, where the well might be, or where the point of diversion on the stream is. And we'll hold another public meeting like this to discuss any questions. Again, there's a 90-day objection period, so if people don't like what's in the proposed determination, they can file objection. Again, that's got to be filed with the court. Don't file it with us, because we're now in full-blown legal proceeding, and then that has to be filed with the court. We have to resolve those objections. Usually we either do that by amending the proposed determination if it's an obvious mistake, or stipulating with the objector, or seeking the court to, or litigating it and having the court dismiss it. And then we, again, want a final decree, an interlocutory decree on this particular subdivision, which will eventually be wrapped into a comprehensive final decree for the entire Utah Lake, Jordan River general adjudication. Well, it's kind of hard to see, but that's just in essence that dashed line there. That represents the Mill Creek Subdivision boundary. And you have the same thing on your notice that you received. Those purple dots, those are actually water right points of diversion that we have of record. Outside, there's a larger scale map of this, so if you want to come look at it afterwards and ask some questions to my staff, you can do so there. But this is kind of a plot of all the water rights that we know of. And so for this subdivision, we have about 256 water rights of record that we know of. Most of them are underground water claims or underground wells. But however, there are more surface rights in this book than others, just because we have obviously Mill Creek on up and a lot of these tributary streams. And as I mentioned, the number of people, entities we've notified, 9,546. You can see how many chose to attend tonight. It's pretty common. Hopefully they're watching online. Okay, issues and anticipated timeline. Out-of-date title, we kind of talked about that. We encourage people to update title for water rights of record. So if you come in and say, I'm pretty sure I have a well, and I'm pretty sure I have a water right, and we pull it up, it's like, yep, there's your well, but it's still in this guy's name. We encourage you to update title, but still file a claim. Don't worry about updating title before you file a claim. Those processes can run in parallel. There's no need to do one before the other. Location of no proof required. So sometimes we say NPR. What that means is during World War II, there was just a lack of qualified engineers because they're all fighting Nazis, right? And so the legislature said, hey, well, I've got a good idea. Since there aren't enough engineers to file proof, what we'll do is we'll just allow people to appropriate small amounts of water, and we'll just take their word that they put it to beneficial use. And so that was great. A lot of people did that and eased the burden and helped people out. But the problem is they didn't have someone who had the know-how how to locate and define that water right, do so, and submit a proof. As a result of that, a lot of the points of diversions we have associated with these NPRs are off or not accurate. And so sometimes when you'll look at our website, and I'll show you how to get our website, and we have an interactive GIS interface that will show you where all these points of diversion are. You might say, well, hey, that's screwy. You show my well being in my doghouse, and it's clearly in my front yard or my backyard. And a lot of that has to do with GIS issues, but a lot of it also probably has to do with the fact that when people filed these claims, they were just looking at a big quad map, for those of you familiar with those USGS quad maps, and saying, yeah, I'm about so many feet south of that corner section, so many feet east. So that's my point of diversion. Well, when we plot that on today's very accurate maps, sometimes those points are located in screwy places. So anticipated timeline, December 2017. Like I said, it's probably going to be, I want to say the 15th of December. I'm not sure. Josh did not. He's still out there. Okay. I think it's going to be the second week in December. We will send that notice to file claims out. The 90-day claim filing period begins. In March, the claim filing period will conclude. We'll investigate those claims. In June 2018, we'll publish the list of unclaimed rights. So you wonder, why is it such a long time? Well, we got to, there's people file extensions and then people file retroactive extensions. So there's a lot of court issues that we got to kind of deal with before we can actually publish that list of unclaimed rights. And State holds a public meeting like this again, and the 90-day objection period for the list of unclaimed rights will begin in September of 2018. That objection window will close, and hopefully by January 2019 we'll publish the proposed determination. So we'll get rid of all those rights that were abandoned, and we'll just focus on the claims that were filed. We'll go out, we'll investigate them, we'll kind of do our best to figure out how these things interact with one another, and we'll make our recommendation to the court. The 90-day window to file an objection will begin, and in April 2019 that objection period will conclude, and we'll petition the court. Once we resolve any objections, we'll petition the court to file, order a decree on the proposed determination. Will I lose my water right? We've kind of talked this over, but water users are using their water right in the conformance with how the records of the state engineer dictate. Don't really have anything to worry about as long as they file a water user's claim within the prescribed time frame. Those who don't have a water right of record are required to file a claim, otherwise they will be barred from doing so in the future. Remember, they're going to be cut off. No more filing of claims through this process. That's what this process is meant to do, is like, hey, we want some certainty. We want to know who is using water and who isn't. We want this done. And so that's one of the things that we is really important for people to understand. If the water user's authorized under the water right and has fallen out of use for a period of 7 years or more, we may recommend that either the water right or a portion of that water right be disallowed in the proposed determination.
When does that 7 years start? In other words, are you flexible if someone says, well, I haven't done this in 20 years and they're just finding out about it? Can they show that they're using it and you guys say, yeah?
So I'll kind of reiterate what I said early on. It's like, if we come out and people are using their water, we're not going to go CSI water rights and do some investigation on it, right? But if if we come out and they're not, it's hard for us morally or ethically to say, we want to be consistent, and so we just want to make sure. So this is kind of like, when you stomp your feet, that's like the big hint. Make sure you're using your water when we come out and evaluate it, right? This is your best way to make sure that you're not going to fall into this 7 years. So it's a rolling 7-year window, and we just look at the last 7 years. Yes, ma'am.
Just any usage, is all usage in the same validity? Like if somebody's using for irrigation to grow a garden versus somebody else that's using the water in like a riverbed for aesthetics, does one of those have a higher precedence?
This is a great question. So our question is really about the beneficial use. What constitutes beneficial use, and is one beneficial use better than another beneficial use? So there are some things that don't constitute beneficial use. Unless you're certain government agencies, you can't have in-stream flows. But certain government agencies, and even like Trout Unlimited, they can own water rights for in-stream flow. So aesthetic purposes is not a recognized beneficial use. However, fish ponds are, right? You have fish in them. So it's just a weird thing. I get it. But for the most part, if you have a water right recognized on our records, it's going to prescribe what those uses were originally appropriated for. So when you apply for a water right, in the application you say, I want to irrigate 5 acres, I want to water 10 cows, and whatever else, right? And then your claim, we'll send you the claim, and it'll have 5 acres and 10 cows in your house, or whatever you've filed your claim on. So the beneficial use isn't just like whatever. It's usually whatever it was used to either pre-statutorily or whatever's on your water right already of record. Yes, sir.
How do we demonstrate that we used the water for 7 years?
So his question is, how do you demonstrate that you use the water for 7 years? You don't need to. Demonstrate that you're using the water when we show up. And make sure it's not obvious that you just didn't barely start doing it. Yeah, I'm not, like I said, I'm not in the business of being the water Gestapo. It doesn't bring me a lot of joy to take people's water rights away. I know that that's the perception, but trust me, we truly try to help people understand this so that they use their water. All right, did I see let's go back. I'll 1 second. Let me get back. Ma'am in the white coat.
What is going to happen to unclaimed rights? Is there going to be a monopoly that's going to sweep them up?
So our question is, what happens to those unclaimed rights? Is someone going to get those? No, they just go away. So if you imagine a stack of papers, and the top paper gets the water first, and the bottom paper gets the water last, and the middle paper is the right that's on the list of unclaimed rights, and it just gets pulled out of the stack, and now suddenly the bottom paper is one paper closer to getting wet water at the end of the year. It doesn't go anywhere. It can't be resurrected or used or purchased. I guess someone could buy it. I wouldn't buy it. It's a terrible investment because you can't use it. It just goes away. That's right. Yes, ma'am.
And so there are, it comes around May, so what would happen with the engineers?
Yeah, that's a great question. So she brings up a good point. A lot of irrigation companies have a period of use of which they're authorized to run water through their canals and irrigate. And obviously people aren't going to be irrigating in dead of January or dead of February, right? We understand that. Usually it's pretty easy to see that irrigation has been taking place. We have historic aerial imagery through Google Earth and through other means to kind of get a good feel for that. And if we go out there and the head gate looks like it's in good shape, it's not hard to determine when someone's irrigating. It's more hard to determine if they've had 5 cows on that property in the last 7 years or not, because how are you going to count a cow and they just bring the cows on the day you show up? So irrigation's not that tough to determine. Yes, sir.
The ditch that goes through my yard ends up watering a very useful grove of trees that's on city property. Do they need to file a claim?
So the ditch that runs through your yard ends up on city property that irrigates a grove of trees. I presume the trees are just drinking from the ditch naturally. It's just they're benefiting because they're planted next to the ditch, right? Does the city need to file? No, because that wouldn't really constitute irrigation in our book. It's just naturally occurring, what we call riparian benefit. And so Utah doesn't recognize riparian rights or rights that happen to occur because you are adjacent to a water course. Yes, sir.
Is your office flexible if water is being used beneficially, if it's being used for a different purpose than what the certificate?
It's a great question. This question is, are we flexible if water is being used for a different purpose other than what's authorized on the certificate? And, fortunately, we have some Utah Supreme Court case law that dictates the precedent for that. There was I guess it's relatively recent actually. Bottom line is, if you're using the water, the court has said, if you're beneficially using the water, even though it's not the authorized use prescribed under the application, you can't be forfeited, right? That beneficial use, even though it might be used for something else, preserves the water right. And so usually how we handle that is we let people know that, hey, your water right doesn't cover that, but we recognize that it's being used for that, so we're not going to forfeit the amount that's being beneficially used, but we will write in the proposed determination, this water right has a use of this. When we viewed it or when we inspected it, an authorized use of this was occurring in violation of Utah law. And so that's kind of
So can the adjudication then clean it up by changing?
we will not change the nature of use. There is a process for that. It's the change application process. And that's really what the comment says. A change application has not been filed in conformance with Utah law. And so you can file a change application to make it right. And that's really the avenue to do that. Because what a change application does is it sends out notice to everyone that, hey, I want to file a change on this use. So it's a due process issue. And so the policy is, by my boss, the state engineer, that we don't recognize accomplished changes. We might recognize the amount of water associated with that, but we're not going to change the use for them. They need to go through the change application process. Okay, so let me do this slide and then we're done. So hey, this is my contact information. I'm there at the top. My assistant, Gary Brimley, is my adjudication engineer, kind of second in command. Josh Zimmerman, he's the team leader for this subdivision. He's going to be running the boots on the ground. Most of your questions will be answered by him or his staff. So I'd encourage you to call that number or use that email address. But again, feel free to use any email address. Feel free to contact us in however you want to contact us. Okay, I'm just going to check online really quick, see if there's anyone emailed those questions in, and then we'll turn the questions over to the body of the group here. Hold on. Okay, no one emailed a question. So, yes, ma'am.
Is there any charge that would be incurred now at the time that we're doing all this and down the road to bring this into order?
So her question is there any charge that would be incurred as a result of this process if they're beneficially using water or that would be used down the road, right? There's no charge associated with our process. There might be charges from ancillary things you decide to do to make sure your water right is firmed up, whether that be through hiring a lawyer or hiring an engineer to do something. So those are charges, but those are all up to you. But there's no charge to participate, to file a claim, or anything like that.
So if I have a well, it's mine.
If you have a well, you continue to use it. Generally, there's no assessments associated with a water right. Now, obviously, irrigation company shares, you have assessments that you pay on those. But privately owned rights, there's no annual fee or anything. It's our property right. And it's not taxed or anything like that. Let me get this lady in the back here, and I'll come back to you. Yeah, there is a website. Let me answer this gentleman's question, and then I'll bring it up and kind of go through how to get to it and what it looks like. That's a great question. Yes, sir.
Okay, our water company has an exchange agreement with the municipality.
Mm-hmm.
And they have never used the water that we exchange. Do they lose that water?
This is a good question. Lots of good questions tonight. So his question is, his company has an exchange agreement with a municipal water supplier. And they have never used the water which they have exchanged with this company. Will they lose the right? Well, public water suppliers have better lobbyists than the rest of us. And so they've got the legislature to insulate them against any type of forfeiture action. So the answer is no, they don't lose their water rights. That happened back in 2008. And so what they, in essence, say, if the public water supplier acquired that right or an interest in a right prior to May 5th, 2008, it's not subject to forfeiture as long as it's part of their 50 or 40-year plan, right? And, you know, if you can't find an engineer to create an imaginative 40-year plan that fits all your water rights, and go find another engineer. There's always someone to do it. So let me show the really quick how to do the website navigation, and then we'll answer your question, all right? So I want to show, because this is really a kind of a slick interface, and I think you'll find a lot of value out of it. So give me a second. Let me get it set up. No, better not do that. All right, I'm going to go off camera here. So if we go to our website, so the website, water rights, one word, utah.gov. Under data, you scroll down to this GIS maps link. Select that. And then up in the upper left-hand corner, there's a water rights maps link. And you can just select the first one in the list, adjudication areas. And it brings up the entire state. And all those purple lines are different subdivisions of adjudication areas. Okay. Let me zoom into the Mill Creek one. And hopefully our server plays along nicely. It's just been running really slow today, so looks like it's doing all right. So let's go to the Mill Creek book. 5715. So that book, that's the adjudication subdivision we're talking about right now. Okay. And let's just zoom in a little bit. So you can see just an aerial imagery. So once you get there, you see this tab over on the right-hand side that says layers. This has a bunch of different buttons that you can select. The one that you're going to want to select is points of diversion. and then you got to give it some time. All those red icons represent wells, and they have water right number, their respective water right numbers associated with them. The blue icons represent surface diversions, okay? And so you can see that the cluster of wells grows in density the further west you go, right? That's because they're back in the day, they didn't have public water suppliers that ran service out there, so they all drilled free-flowing wells, and that's how they got water to their house. So we have a lot of those, and a lot of them have been abandoned. But if we're going to zoom in, let's just pick on this one right here for a second. And I know this is a more recent one because it's got a high number, so that's why I'm picking on it, just because hopefully things are in order. You can select on the icon, and it'll bring up all the information about it. And this is actually an unapproved application, so I'm not sure why it's even showing up, but it's for Jordan Valley Water Conservancy District. Let's not select that one. Let's go to a private owner. Here we are, Joseph Wagstaff, much better. So in that, you can see, and I'm going to point to the screen here, that's the water right number. UGWC stands for Underground Water Claim. That means it was drilled prior to 1935, as indicated by its priority date. So this is one where people have actually filed an underground water claim to recognize their pre-statutory right. Uses, domestic irrigation stock. That's the flow rate of the well, 0.022 CFS, or cubic feet per second. That's the owner that we have on our records. It's an underground. That's the location using the public land survey system. So it's a meets and bounds type description. So to decipher this, you need to pull out your Rosetta Stone, and it's south 287 feet, west 97 feet from the east quarter corner of section 32, township 1 south, range 1 east, Salt Lake Basin Meridian. All that's saying is there's an imaginary grid on the ground. There's a corner in that imaginary grid. This is located so many feet south and so many feet west from that corner. So if you were to draw over and down, so you would draw down 287 feet, and then you draw west or to the left 97 feet, and that's where this point plots. Well identification number, I'm not going to get into that, but if you select the link up at the top, it'll take you to our database. Okay, and so this really has all of the information. So that had just kind of a snapshot of the information. This is really, oh boy, let me fix something really quick. Oh, thank you. So this has more detail. It has Joseph Wagstaff, has his address, the owner of record, has any interest. Sometimes there will be multiple owners of a water right, and they'll have their interest indicated here. It has a lot of different information. A lot of this isn't filled out because it wasn't an application to appropriate. It was an underground water claim, so a lot of this information is not pertinent. But there is the priority date of when it was drilled, when the well was drilled and put to beneficial use. Scroll down, there's the flow rate, The source is underground water well, county, Salt Lake. Here's that PLS description again, a little bit more spelled out. Depth of well, diameter of well. And then it has this thing called a water use group that I don't want to get too much in the weeds, but these are all the beneficial uses associated with this right. It was originally appropriate or used to irrigate 0.13 acres. There were 22 head of stock on there. It's back in the day, obviously. I doubt there are 22 cows roaming around that landscaped yard. And they used to appropriate water by how many people would drink out of this well. So in this case, let me see, 1.4 would be like 7 people. So they probably said, oh, there's 7 people that drink from this well. Well, these days we use different units. We use equivalent domestic units. So in essence, one equivalent or one EDU or one equivalent domestic unit represents one house. And so if this were to be done again today, that would just be one EDU, because we just say we're not going to worry about the number of people. that fluctuates, but generally speaking, it's used for one house. And this matrix down at the bottom is just the place of use. So it's the location of the irrigation is in the northeast quarter of the southeast quarter of Section 32, Township 1 South, 1 East. Again, it's an imaginary grid, and it just kind of zeroes in on the portion of the grid in which it's used. Okay, so that's how. Anyone have questions on how to get here or access this, or what? There's some really neat features on this that you can use. Again, I'm going to go off camera here. You can change up the different base maps. So if you want to do Google imagery instead of Esri imagery, if you want to do topo maps, another good thing, if you go camping a lot, you can always get a free topo map off this interface. You can always print it off. So, of course, you can get those online as well. But anyway, some good mapping features here. If you want to search for your home address rather than if you're not very good at figuring out where you live in an aerial imagery type interface, you can put in your address. Like our address here is 1594 West North Temple, Salt Lake City. And it will take me to that, puts a big X on this building. If we zoom out, you'll see the points of diversion. Again, I still have the points of diversion layer highlighted. So there's other components there. If you want to know the dimensions of an area, you can do this and just find out how many acres it is if you're trying to prepare your claim. If you want to know how far it is. So there's some other things. Lots of stuff to play around on there. You could spend hours. Any questions? Yes, ma'am.
Okay, so if you're an irrigation company, or if you're dealing with them, what kind of information do you request to have them indicate that they're using their entire water?
So her question is, what type of information do we require irrigation companies to file to show that they're using their water right? Is that a good summary? It's going to be on the water user's claim. Let me bring one up to show you what it looks like, okay? I'm just going to bring up a blank claim. So it's on our website. Let's see, go to data. I got to figure this out because I never go to this. I don't know, here we go. Applications and forms, okay? And then down near the bottom, adjudication forms. Here's a water user claim form, right? I'm going to pull it up. And it's going to look a lot like what was on our database. So this is just legal stuff. If you come in, we'll fill out that part for you. But if you come in, we'll help you fill out all of this. But these are the names. So the water right owner, the source information, maximum diversion rate, how much water can it pump out. The point of diversion, that's the location based on the public land survey system. Again, we don't expect you to really be super conversant in that, so we can generate that for you. The most important thing is to fill out as much as you can and make sure you indicate what the uses are. So section 3 down here, water use information. Irrigation from when to when. Down here in line C, how much, how many acres, sole supply, don't get too hung up on that. How many domestic, how many EDUs, whatever you're using the water for. And place of use, again, is going to be a legal description. If you have troubles with that, we can help you out. But this is the claim. This is a blank claim form. The water company, if they have a water right of record, will get this already filled out. All the information will be generated, and so they just need to go through and review it. All right. Any other questions? Yes, ma'am.
Will we be notified when I don't know if my water right exists, or if it might have gone unclaimed when I bought my house. I don't know how all this is going to shake out. So my question is, it's something that we use, that we actively use and landscape with, but when somebody comes out to inspect it, there's a pump that we put in that we use out in different places in our yard. So will we be notified when they inspect it?
Yeah, certainly. Yeah, yeah. If you put your contact information on there, my guidance is to my teams, always reach out to the claimant so that they can show you how they're using their water. So they'll contact you. Yes, sir.
What if there are springs on our property, but the water right is owned by a municipality across the street? We would like to access it, but, we're not gonna invest a lot of money putting pumps and water towers in until we know we have the right. There's no doubt that they have the water rights. Can we file a claim for how much water we think we might use of their water rights and let them have the rest of it?
So this question is, so kind of give some context, background. There's some springs that are the water rights are owned by municipality. Springs fall on your own property or property of condominium HOA property. Can we file a claim on top of those and then claim whatever water we think we need, and then the municipality gets the rest? I'm going to tell you right now. So claims aren't for prospective use. Claims are only for what has been going on or what you have a right to use. If you want a prospective use, meaning you want to use something moving forward or in the future that you haven't been using, you need to acquire a water right from someone. You either purchase it and file a change application. So to kind of give you a general idea, that there's just no chance that the municipality would ever let you do that. Knowing municipalities. And if you file the claim, unless you had been using it prior to 1903, we would not be able to recognize it. So there's no leverage that this gives you over some other entity, whether it be a municipality or a private water right owner, that suddenly allows you to sneak a claim in on top of them and take part of their property, because that's what it is. So that kind of answer your question? All right. Yes, sir.
We're up at Mill Creek, and we have a small power plant. So we have the intake, turn the margin right and goes out.
Mm-hmm.
Do we have to file a claim?
So you have a little hydroelectric generation thing going on. So the neat thing about that is it's not a consumptive use, right? Water comes in, it goes out, no harm, no foul. You still need a water right for it. But the nice thing, I said that the Salt Lake Valley is closed to new appropriations. What I really meant, it's closed to consumptive appropriations. It's still, as long as it's still open to non-consumptive appropriations. So if you wanted to have a water right, which you probably should, any use of water, including power generation, should have a water right. And so if you didn't have a water right already, and I'm not sure, like, if this is a pretty substantial operation, I imagine they have a water right. If it's not, then... Well, so all we're concerned about is file the application, but yeah, I guarantee you, there's going to be some issues of people who might protest that application. All right, so in the appropriative process, you file an application to appropriate delineating your beneficial use you want to use, right? And how much water you're going to use and what it's going to look like, where the point of diversion in. And then that gets advertised, and then people have an opportunity to protest and say, no, that water right will impair my water rights. So they can protest it, and then it goes to the regional engineer, state engineer says, well, I understand your protest, not really concerned about it. We're still going to approve the appropriation. So there's always the ability to do that. One thing about the appropriations process is, we are only looking at, in a sense, from the state engineer is only worried about impairment issues to other water rights. It's not we aren't the gatekeeper of the ecosystem. We aren't the gatekeeper for the Forest Service. But all we care about is this going to impair other people's water rights. And that's the justification we have to look at when we approve applications. And so I wouldn't be necessarily so just know that people will protest, but depending on the validity of their protest, they have to demonstrate that they will be impaired by this hydroelectric system you have for it to be not considered approved. But again, that'll go through the regional office, and they have their own policies that they follow. But if it's a non-consumptive use, it may be open to appropriation. Eric, you want to comment on that? Yeah, non-consumptive use. So Eric Jones is the assistant regional engineer for the Utah Lake Jordan River region. So he's a great person to ask about this applications process. Sure.
But what you have asked too, that has always been kind of a dark cloud hanging over. Is there what you can see as being the Division of Natural Resources and caring about the water? Do you see that the creek will be taken to use for water in other parts?
See, my opinion is if there's existing rights on it, no one can take the creek, right? Because those rights can't be impaired. And so it doesn't matter if it's Didi Cordini or Donald Trump, those are rights, and they're property rights, and you can't just take them unless it's through forfeiture, right? So I don't see an issue. The only thing I can imagine that may happen, and I'm not familiar with this situation, is that if there were some rights on the creek that people sold to a municipality or something like that, then they would be able to divert that water and use it elsewhere. But if there are rights protecting those beneficial uses, I have a hard time imagining how anyone could just come in and say, nope, we're taking this, tough luck, Chuck, have a nice day type of thing, right? So I think as long as you guys got beneficial uses and rights protecting it, that's the importance. I mean, that's one of the benefits of having a water right, right? It's a property right that's now protected, and that's why you want to have it on record. Sir, I'll come back to you. Right. Mm-hmm.
With this process you've gone through, just appointed a version you have to bring up, or is it passing those parties?
Yeah, that's a good question. So it's really, we use these boundaries as a mechanism to make sure we don't miss anything, right? And so what we say is if you have appointed diversion within this boundary, your water right is going to be included in this process. And so the Mill Creek rights, or the company, would probably end up in 2 proposed determinations, but they only need to file claims once. And so the claims they file once, we'll just look at them again and recognize them again in the following proposed determination. So there won't be much of a change. They'll just end up in 2 different proposed determinations, and it's mostly just kind of a mechanism to make sure we don't miss stuff. So, yeah. And inevitably it's going to happen. I mean, you can imagine this happens quite regularly, actually, where the borders, we try to align borders hydrologically so we avoid that type of stuff, but in cities it's impossible. So, did you have a question, sir? Where's the video going to be available online? That's a great question. So if you go to on your notice, it says there's a link that says watch lives, like utahwaterrights.gov, watch live. You can go there, and then it'll say, and so that's only for the live presentations, but there will be a little link that says show past presentations. And so you can get there. So that's the easiest way. There's a different way, but I'm just going to give you the easy method. Just go to that link and then look for it, and it'll take you to a YouTube page. Okay. Yes, sir. So really, to recapture your question, you're on a turn schedule. On the turn schedule, you have 2 hours, right? You have a 2-hour turn. However, in order to make sure that this grove of trees remains vibrant and healthy, you've turned it on for 24 hours. From our perspective, that's an internal company issue that the ditch master should come over and probably get after you a little bit, right? Because the water right, from our point of view, has nothing to do with hours and turns. It's just this much water for this much irrigation. And then the irrigation company says, okay, well, we have this much water come down the stream. How are we going to equally distribute this among different water users? Well, I got an idea. Let's just give them so many turns off the ditch, and that's the way we can do it. And so that turn schedule is kind of an internal mechanism to ensure that that water is being distributed fairly among the shareholders. But to us, it's transparent, or I guess it's just not. We don't see it. It's not really an issue for us. So So you don't really have a water right. You have a share in a company. The company has a water right. And there may not be, but you have shares in a company, right?
Well, not that I know of.
Well, so how do you know what your turn is then?
Well, this is an old orchard, you know.
No, but how do you know how many hours of a turn you have?
It's a handwritten document.
Signed by, associated to, pay.
Who was the orchard owner.
Yeah, we'd have to look at your, I'm not sure what you're describing, so we could certainly look at it a little bit closer and come up with some conclusions, but I'm not sure whether you have a water right or a share, to be honest with you. Usually turn schedules are associated with shares in a company.
I mean, I do have a warranty deed that says I have 2 hours water right associated.
Okay. Well, we can look at it if you want to bring it in and we can discuss. File a claim on it and we'll figure it out. Okay. Yes, sir.
I need a clarification on your earlier answer about change of beneficial uses. So I understood you to say the Supreme Court decision prevents forfeiture. The adjudication won't clean it up, but it's going to be noted that there's a violation. And you need to file a change order with the state engineer to get that, or change application to get that change. What if the state engineer says, so I don't want to make the change, but the Supreme Court decision says you can continue using, but you're in violation?
Well, the Supreme Court doesn't say that you can continue using. You're still breaking the law, actually, okay? All it's saying is that the water right hasn't been forfeited. So there's no, it does not condone using the water right beyond the prescribed authorizations, okay? And quite frankly, it's possible that the state engineer wouldn't approve the change application because maybe it's a more consumptive use, maybe it would impair some other water users, but you've simply done it in violation of the water right. So there's no obligation because you violated the law to make you whole in terms with what you violate. I mean, that would kind of turn the system upside down and reward people who have, gone and done that. All the Supreme Court has said is that it doesn't constitute a non-use of water because you're using the water, so you can't be forfeited. So that's where you end up. Sir?
Is there a place that we can go and verify that he has the water claim, he's actually put the claim in? I'm a little bit from East Millbrook Water Company. I just want to make sure the Salt Lake City record do justice.
Certainly. No. His question is where can we verify whether someone's filed a claim or not? If you go to the water right, if you know the water right number under which the claim is to be filed, let me show you really quick. Well, if you go to this interface, right? So if you go to the map and you select, this is where it's diverted. This is our water right owned by Salt Lake City. You see this menu, this drop-down menu right here. There's a selection called Scanned Documents. So what that shows everything we have on hard copy upstairs will be in this Scanned Documents folder. And so you select that. And what will happen is when Salt Lake City files their claim, we will scan it and we'll put it on the file and we'll scan it and it will show up here. So you can see this is the original underground water claim. And it looks like even, someone's, you can ignore that. So water users claim at the bottom, that's showing that we're sending it out. You can see the date. It's actually in the future. It's December 15th. That's because we've generated the claims for the owners of record, and we're going to mail them out on December 15th, and we decided, well, we'll just stick them on the. So that doesn't constitute a signed claim, but what it'll show up as a water user's claim, and then it will say signed Salt Lake City or something like that. And so you can verify that, hey, they have filed a claim. Let me come back to you really quick. Yeah. You
So how would we know, like, I've been told that I have a water right or a water share. I'm not sure which, I'm not really sure the difference of which, but somebody comes out to our ditch and they clean it out and they put like a conduit in a couple years ago. I think it was Mill Creek Water Company, and then I've also heard that they dissolved. So I guess my question is, if we have water that we can use for beneficial use, that we do through, that we have share or right or whatever it's called, but we're using water, how do we, if we don't actually have a right that exists, how do we make a case to have a claim and obtain a right if one doesn't exist? I don't know.
So there's kind of two different things we're talking about here. So the question is, I'm uncertain whether I have an irrigation share or a water right. I just don't know. I don't know if it's part of this Mill Creek Irrigation Company, which is dissolved, but I don't think it is dissolved. I think it's a pretty vibrant company. I think it actually has has a website on it. So yeah, talk to them. But at the end of the day, what I recommend doing is just filing a claim and getting your foot in the door, and then we'll figure it out. And if you have a pre-statutory claim, it sounds like what you have is shares in a company, and if that company is gone defunct, that doesn't matter to us. There's still a water right on our record that would preserve it.
But I guess if we don't actually have anything that exists in your system right now, it sounds like through this process we'll be able to validate that, prove that, and get one created.
Not necessarily. If you wanted to, so you could always file a claim, but if you cannot, and if it's a claim not of record, if you cannot demonstrate through evidence that that water was put to use prior to 1903 for a surface right or prior to 1935 for an underground right, we will not recognize it. We'll recommend that it be disallowed. You can't, because after 1903, the only way to acquire a water right for surface waters was through the appropriations process. Same thing for 1935 for an underground right. And so you can file a claim and say, hey, well, my great-grandfather started diverting water from this creek back in 1956, and you can show all the evidence in the world. And we say, that's great. He did it without a right. It's illegal, and you don't have a valid water right. But if you can demonstrate, hey, we can take it all the way back to 1903, then they say, good to go. You got a right. Well, yeah, there's some common law associated with prescriptive easements for water conveyance systems. That if there is a ditch that crosses your yard and it conveys irrigation water, then they have right to access it. That's actually in the Utah Code. So they have no obligation to give you anything other than they can't damage any property. Yes, ma'am.
Does owning property on Mill Creek, being a property owner with creek front, does that constitute automatic right?
So our question is, does owning property along the meander line of Mill Creek constitute a water right? And the answer is no, because that would be a riparian right, which is back east, right? We're an appropriative state, so we have two concepts of water law: riparian and prior appropriation. So no, you'd have to appropriate it through diverting it in beneficial use, as previously discussed.
So if I can't prove, I haven't been using it since 1935, I'll be out of luck unless this Morse decree, the property I'm living on was listed there, then I have a shot.
Well, you may still have a shot, but if you haven't been using it for the last 100 years or last 50 years or last 7 years, we would recommend that it be disallowed.
I've been
If it's in the decree and you've been using it, good to go. Yes, sir.
Question here. The title department today requested a quitclaim deed from an ex-spouse to establish that a water right had been transferred. And you said earlier that it's presumed to be appurtenant to the land and therefore assumed to be transferred. So the title department is contradicting what you said. Can you tell us who is
I'm not sure who you're talking about, the title department. Who are you talking about? Here, the Division of Water Rights?
Division of Water Rights? Yes.
Well, the quitclaim deed would be a way to specifically withhold the right or transfer the right. But if the deed conveying the property occurred before the quitclaim deed, then it's already gone. There's nothing to convey via quitclaim.
No, but there is a warranty deed that transfers the land, but it didn't transfer the water rights.
If it's silent, it did by appurtenance, unless it was explicitly already conveyed somewhere else.
Well, this is what we understood, but we were told today by the person who's cleaning this up that the title department is happy with everything, except they're saying that the warranty deed did not transfer the water right by appurtenance. So I'm wondering, who's the person who heads up the department that we can appeal to?
Chris York.
Chris York.
Give him a call. He manages the title department, and he'll be able to get to the bottom of that. Because I don't think I have all the variables in front of me. Oh, is there? I'll check my email really quick. Hold on.
Thank you.
Yeah, it's 0. I'm sorry. You've been very patient, and I'm happy to answer your question now. You got the floor. Yeah, we can cut it. All right, well, this concludes probably the substantive portion of this presentation. I think we're going to wrap up the AV portion. So those of you viewing online, you're welcome to email me questions, give me a call, happy to answer those. But we're going to conclude this presentation at this time.